Welcome everyone to this week's NYM community call. Sorry for once again, after last week we had it on Friday and now we have it on Wednesday. We had to move things around a little bit, but this is the only time Simon could make it, and we have a very interesting chat for you all planned today. So thanks everyone for joining us. And also thank you, especially Simon, for joining us. I have with me today Simon Schlauri, who's a legal expert in Switzerland. I don't even know how to introduce you with such like a long resume, so I will first ask you to do that yourself. But before that, I wanted to share with our community that, of course, as usual, we will have a Q&A at the end of this this chat. So if you have any questions to either Simon's, because you know, I'm also Simon. Then make sure to leave them in chat, and we're going to be addressing them at the end of the call. As always, the call is being recorded, so if you want to check the recording or you can't watch us live, then you can find this on the NYM YouTube channel as well. Now, with all of that said, Simon, it's a pleasure to have you on. You're, of course, a pretty... I should have probably introduced you as Professor Dr. Simon Schlauri. That's the full title, right? You're obviously... Yeah. A dedicated legal expert in Switzerland. Can you please introduce yourself and tell us a bit about your background to the community?
Of course I can. Thank you very much for having me here. Hello, everybody. First, my name is Simon Schlauri, as you can read, and I am a professor of law at the University of Zurich. And I work as a lawyer, as an attorney at law in IT and telecoms law. We have our law firm, Ronzani Schlauri Attorneys. We've been up and running for about, let's say, 13 years, something. We have offices in Zurich and in St. Gallen in eastern Switzerland. Yeah, and as I said, my focus is IT law and privacy, and yeah, I have some nice, let me say, high-profile cases in this area, and that's also a reason, as far as I've understood, why you invited me here. So,
is it fair to characterize you as a privacy-focused lawyer?
Yes, definitely. I mean, privacy is one thing we do. We also do competition law. We have telecoms matters we're dealing with, but privacy is a big chunk of our work, definitely.
What, if you don't mind me asking, what drew you to this this specific field within law?
Well, I've always been a tech person. I wrote my own software when I was a teenager, and during my law studies when I was 25 years old. I've always been following the whole, not only privacy, but the whole let's say digital rights discussion, discourse. I've been, well, yeah, a member of Digitale Gesellschaft, Digital Society Switzerland, which is a digital rights advocacy group, which is quite big in Switzerland. I've been a member there for I don't know, as long as they've been here, might be 10 years or even more. So I've always been in touch with these people, and it's also something I really find important on my own. So it's not just a business thing, but it's also, for me, for myself, privacy is important. I'm also an advocate of digital sovereignty of Switzerland. I do not like the idea of Switzerland being dependent from any other states with regard to data that is processed by the state, for instance. That's all ideas that are around me or have been around for many years.
The reason I asked this pretty leading question is to show our audience exactly why you're here. Now they understand this is, of course, all that NYM stands for. And the other thing that connects you and us is, of course, the Swiss jurisdiction, which you understand very well. Obviously, NYM is based in Switzerland. And something I wanted to talk to you about is this notion or this idea that a lot of people have, me too, maybe you can correct me if I'm wrong, that Switzerland is a privacy haven. It has that reputation globally, I would wager. And then a lot of privacy-first companies, you know, such as Threema and Proton and NYM, and I could probably list a few others as well, are based in Switzerland for this reason. So I wanted to ask you, from your perspective, where does this reputation come from, legally speaking, and, you know, whether it's accurate or not? What are your thoughts?
Well, it is accurate on one hand because we have a data privacy law that is at a similar level as the EU, the GDPR is. So this is sort of the gold standard. And above all, we have, well, our state is governed by the rule of law. So we have courts. You can ask if some administration is trying to get in touch with you, is trying to get data from you. You can appeal to courts, and this rule of law and the legal procedures work quite well in Switzerland. So that's a reason, that's an experience that I also already made. We had some important cases there that we won against the federal administration, and where we could defend privacy against some people who, let's say, exaggerated from the administration.
But then when it comes to, as our advisor, Bart Pernille likes to say, he says this a lot, and I have to agree that, the EU has two faces when it comes to privacy. So there's, on one hand, you have GDPR, which is an absolute trendsetter in end user privacy focused regulation, and on the other hand, you have the constantly renewed and reoccurring push for chat control and some other not so privacy first ideas. Would you say that Switzerland is in line with the EU, or are you guys better than us in this sense? I'm by the way, I live in the EU, born and raised.
Well, there is no such thing as chat control in Switzerland up to now. Of course, you always have criminal prosecutors who try to introduce these things, etc. But as we have we have a direct democracy. So you need, in case you want to introduce such things, you need vote. And that's I'm not really sure if these things would pass a vote, to be honest. So there is sort of an additional, let me say, border that you would have to cross, which might be a bit difficult to cross in that situation. But of course, there are people who try to, let me say, get more data from internet services. There is, you will probably talk about that later on. There is a revision of the surveillance law in Switzerland is underway. That might be a reason to talk about. And of course, it's always the question of how far will this go? But at the moment, yeah, this is still open.
Yes, we will definitely get to that. I would love to hear your thoughts about that I think proposed regulation so far. But before that, I wanted to also ask you, when it comes to, again, like I mentioned, a lot of privacy first companies choose Switzerland as their base of operations and the jurisdiction in which they operate. What does this mean for the users? Is it any different from operating in the United States or maybe another country in the European Union or something like that? Is there any meaningful difference?
Well, I would say yes, there is a difference. I mean, first, as I said, if authorities try to get in touch with such company, with Swiss companies, you always have the possibility to appeal against these decisions, and the companies you were talking about are definitely trying to keep privacy, trying to defend privacy against such tries of the authorities. So I think that in the bottom line, we have a level of privacy that is probably better than elsewhere. If you look at the United States at the moment, of course, if Mr. Trump is trying to get information from one of the American companies, it might be difficult, factually be difficult for them to defend. And in Switzerland, you do not have such a situation. You always have the possibility to go to court, and quite often it works so well.
Yeah, so part of the, maybe on one of the bottom layers of an individual's privacy actually is the laws and regulations, and to some extent the mindset of the jurisdiction. So that's a good point. Now, the other thing that is at the base layer, at least when it comes to NIM and our philosophy, we have this philosophy that we build privacy directly into the software. So it's the sort of Bitcoin no trust, don't trust, verify type of approach, right? But on the other hand, we do have, some policies to support and clarify the areas, that we don't control, or maybe, in the case of the terms and conditions for an independent network of operators, just to set out that they can't surveil users on our network. And then there are also some gray zones which we clarify through these policies. This is of course, our approach to like the legal aspect. Obviously, technology is first and foremost provided and ensured on the technological level, but there's also like a legal side to this. And I wanted to ask you, where do you see the law playing an important role, in supporting privacy first apps and infrastructures?
I'm not sure if I got you correctly, actually. Can you probably just repeat it?
Yeah, sorry, very long-winded question. Let me just ask the question part, repeat the question part. So where do you see the law playing an important role in supporting privacy-first apps and infrastructures?
Okay, well, the first point is, but this is the same as in GDPR, this basis of privacy by design that you're following very strictly with your products, of course. And actually, the law says that as a company who is processing personal data, you have to decide first which data you really need. You have to implement measures as good as technically possible to protect data. And if you're a company like NYM, you can really see that these technologies are in place. This is the first point. The second point is, as I said, I mean, you have the data privacy law on one hand, and on the other hand, you have those ideas of course, criminal prosecutors, etc., to follow, to find out more, to engage in more surveillance, and there, of course, you have some let me say borders. As I said before, you have constitution that protects privacy, and you can, as a company as well, you can try to appeal against these steps and find ways out of it. I'm not sure if this answers your question.
It does, absolutely. Thank you very much. Now, moving on to our next topic, which is I think probably the meat and potatoes of our conversation, and we got this from our community as well. This sort of worries a lot of people, given again this safe haven, or maybe just assumed safe haven status of Switzerland. This regulation, when we first heard the news, it sort of worries a lot of people. So let's maybe talk about it. Last year there was this regulation proposed, which my understanding, and you will correct me if I'm wrong, but it would require digital service providers above a certain size, and it's like a really small size, above 5,000 users, I believe. So, for example, NYM would be well in this range to basically KYC their users, so collect their government mandated ID, I guess, and also store various types of information and logs about them that then, under certain circumstances, law enforcement could ask, maybe through warrants, or I'm not sure, to access. So can you explain this law? I butchered it in a lot of ways, and sorry for that. Can you please explain, in plain terms, what it expects from companies?
I mean, first, to start, of course, we have surveillance law in Switzerland. So if you're a criminal, you have to expect that police will run after you. They will try to tap your lines, etc. And this is, you will probably not find any state in the world that does not have this. We have the rule of law governing these things. So, for instance, if you're a criminal prosecutor and want to tap a line of some person, they have to go to and ask a judge who will decide on that. So you already have two parties that decide on whether a line can be tapped or not. You have a legal basis. You have the law on surveillance of post and telecommunication services. In German, it's BIPF. And this law is quite clear and is quite strict on what can be done and what cannot be done. There is a differentiation between telecom services. So this is let me say, the old style telecom services as phone or internet access and SMS, so the basic stuff. And then is a part that governs so-called, well, I generally say over-the-top services or providers of, in German they say abgeleitete Dienste, so derived services, so services that rely on internet access. And I would say a VPN or like a chat service or something like that. Also, the platform we're using here is an over-the-top service. This is a service, one of those derived or abgeleitete service that is also governed by this law, but providers of these services usually do only have to provide the authorities with data they already have. So they are not obliged to store data. They're not obliged to identify their users, except for very, very big companies that might be upgraded to a level of surveillance that is similar to the level a normal telecoms operator has to provide. And now what happens with this new ordinance that is still based on the same law is that they lowered those thresholds. They lowered them quite a bit. They lowered them down to 5,000 users. And we once had a meeting with parliamentarians where we said that I think it was Proton, who at the first day when they started their service, they already had 5,000 users. So at the first day they started, they would already have fulfilled the requirement to be upgraded to more or less full surveillance. So they introduced, actually to be precise, they introduced sort of an intermediate level of surveillance duties that covers almost everything that the big guys have to do. But for instance, as you said, you have to know your customer. You have to well, identify them either by a phone number or by an ID or whatever. And then you have to store the data for 6 months, etc., etc. So who called whom, who sent SMS to whom, but not the content. You might, if you apply encryption on your own as an operator, you have to remove that encryption. This does not cover encryption that is applied by the user or by a user device. So here we're fine, but actually it was not clear in the beginning if this was meant. You have quite a lot of new duties, and above all those levels, those thresholds where those duties would be introduced have been lowered quite significantly. And that's something that, in my opinion, contradicts the law. So you have this ladder of laws. First you have the Constitution, then you have the law, the surveillance law, and then you have the ordinance. And the ordinance cannot go further than the surveillance law below will allow. So that's the problem we have here, and that was the main criticism that was also brought into the discussion when this ordinance draft was published. There was a consultation on that draft, and the consultation was, except for some police representatives that were happy with it, was extremely negative. Almost everybody who took part in this consultation turned it down. So they decided to draft a new version of this ordinance now, and to have another consultation on this new version as well. There's also a political process going on, mainly because we had companies like Proton who announced that they would, in case this ordinance would really be enforced, that they would have to go to outside of Switzerland. They would have to leave Switzerland because they could not fulfill these duties. And this also, let me say, it brought some politicians to the discussion that thought that probably Switzerland could not just send away or have companies leave the country because these things are not acceptable from an economical perspective. I mean, as you said, Simon, we have some big players in our country that do business that is based on strict privacy. And if we introduce rules that do not allow for this for such services anymore, this is critical for Swiss economy, for maybe also given this whole discussion on digital sovereignty now. There is a big business to make. There is money to make, and if they throw those companies out, in the end, I think the economy will suffer. So this is something we really have to understand, and I think that's also something that people have understood now. That politics has understood, and that also, well, at least I hope, the federal surveillance service which drafted this ordinance has started to understand. So I'm looking forward to a new version of the draft that is hopefully not that strict, that doesn't go that far anymore as the first version that was really criticized in a harsh way.
Okay, so then it's not just my perception that there was serious, significant pushback against this in Switzerland, but actually you're basically repeating the same. That is nice to hear. There was a lot there that we can unpack. Can I ask just to see if I understood it correctly? You said in case the provider itself employs encryption, that's when they have to like remove that encryption, right? But if it's end-to-end encrypted and my client encrypts and your client decrypts, does that fall outside of this ordinance, or?
It does fall outside of it. Actually, it was not clear in the beginning, and that was one very point of harsh critique. We also brought into the discussion there that this norm that asks provider to remove encryption has to be very precise, and that end-to-end encryption that is applied on the device, even by software of the provider, encryption that is being applied on the device itself does not have to be removed. Otherwise, you need backdoors, and this would break the whole security.
Yes. That was where I go with the question. This does ring a bell to me and brings back memories of chat control, which is of course a similar attempt in this regard. Now, I want to ask you, given that you're very technical, so you have this like unique, you sit at this unique intersection of technology. You understand tech very well, and you're also of course a legal expert. Do you see a problem, which we heard, for example, from Bart Pernille? He said that a lot of the times, the problem in the EU is not some kind of malicious intent or anything like that, but just like a fundamental lack of understanding of the details of the technology. Do you see the same happening maybe here with this ordinance or this proposed ordinance?
No, actually not. Actually, in the meantime, after the whole political discussion started, they, let me say, there is a gremium or a body in the context of this authority of surveillance in Switzerland, where they discussed the whole drafts, and we also tried to get a seat in there, and actually we succeeded. I've been since about 3 or 4 months now part of this group, and they we had a possibility to get into this body via the Association of Telecoms Operators, ASUT. And now there are 2 people from ASUT originally, so one person coming from Swisscom, another one coming from ASUT, and me as a representative of those OTT services. We're sitting in this gremium, and after we had those 2 first sessions on those, the new when we discussed the new draft, I had the impression that the people who are sitting in this gremium really know what they're talking about. So there's also technical background. It's not just lawyers who are on a very, very high level, but you also have the technical people in there. So I think this is not the problem.
That's nice to hear. At least that's not a problem.
I mean, there could be, of course, if you appeal against such a thing, if you go to court, then the problem is that in the courts you have normal lawyers who they deal with whatever topics, they have in the courts, and there you might run into problems that you have to convince them that the technical of certain technical circumstances that are not so easy to explain. We usually try to get oral discussions in court, which is at least on the administrative court level not that usual, but we usually succeed just by saying that the topic is very technical and that we would like to explain things orally to make sure that everybody understands what we're talking about. And that was up to now, that was successful, and we had, let's say, good opportunities to explain these things to judges.
That's excellent to hear, especially in the context of my previous conversations with Bart Pernille, who sort of reported the opposite of this when it comes to the EU and EU lawmaking. The other thing that I wanted to pick your brain on a little bit is I think very few people would disagree with a surveillance law, right? In the sense that if there is an identified potential criminal person doing bad things, right, we need to have some legal way to target that person and collect information about them. Otherwise, it's very hard to investigate and stop crime. So that's all good. The where I see a difference between that specific targeted warrant-based sort of personal surveillance and what's proposed here is that basically this also, as a secondary effect, mandates companies like us, or would mandate, I should say, companies like us or companies like Proton and all the others, not just us, not just Privacy First, but any company, right, to perform mass surveillance. And there's a huge difference between these two, right? And I feel like this mindset somehow is lost on lawmakers sometimes, that there is this this difference between individual targeted surveillance in the right cases and then mass surveillance to collect data so that, when we need that data, we can sort of have access to it, which is where the danger lies, at least in my view. What do you think about this? Is this an accurate summary or no? Oh, we lost you there for a second, or maybe you lost me.
Yeah, I'm back. Okay, very good. And you're back too. No, I mean, we have two things that you can do if you want to perform surveillance. Of course, you can tap lines. You can have information that is live sent over the network that is split off and directly sent to the surveillance authorities. And I said before that you need a judge to discuss to decide on that in Switzerland. This is the first point. And there, I think, if you have a criminal or a potential criminal, if you have a suspect, it must be possible for authorities to find out what these people are talking about. Otherwise, you cannot prosecute crimes. The other point is if it is possible, if it should be possible to collect data in advance. So you're talking about mass surveillance. So the question is if it should be possible to collect data of everybody who's using, like say, telecoms networks, who's making phone calls, IP addresses, if this has to be stored or not. And in Switzerland, actually, there is. You asked me before if Switzerland is sort of a privacy heaven. There is a difference between Switzerland and the EU. Because Switzerland still knows data retention for 6 months. Also, for telecom services, basically. For instance, your telecoms operator, your internet provider has to record your IP address for 6 months. And later on, if the police arrives and they say they want to know who had this IP address at a specific time, they will have to give the information. This practice or this law is actually subject to an appeal to the European Court of Human Rights in Strasbourg. The case is still pending. It's been pending for many years. This has been done by Digitale Gesellschaft and Victor Giorfi, a colleague of mine. After the EU court, EU Supreme Courts have decided that such mass surveillance is not legal. So you cannot make data protection, this idea of storing data for 6 months, that this is not compatible with human rights. We still hope that the European Court of Human Rights will also turn down this practice in Switzerland and stop it. As I said, it's still pending. We don't know, and as long as this is pending, authorities are still doing it. And one point, as discussed before, at the moment, the law only provides this for old school telecoms operators. So if you make a phone call over a normal phone network in Switzerland, your provider has to record whom you're calling and at what time. But if you use an over-the-top service, this is not the case at the moment, and that's something they want to introduce with this ordinance. That is, well, based on a law that doesn't provide for it, but you have the ordinance that now says that you have to do mass surveillance and to record contents that have been running over your service. So they try to introduce it. At the moment, I'm quite sure that this is not covered by the law that forms the basis of this ordinance, but we will see if the draft is going to change, can be changed, and if not, if the courts will stop it.
What do you think? So you mentioned a couple of times now this upcoming new draft based on the debate and the conversation that happened around this ordinance. Do you have any expectations on what will change, or maybe any hopes what will change in the new version?
As I said, I'm sitting in this body that is discussing the draft at the moment. There was recently a draft published, which made some changes, but mainly they changed the thresholds on how many people or how many customers you need to have as an OTT provider to fall under the new regulation. And it did not change it in a way as we had expected it, to be honest. It's only, except for 5,000, I think we have 10,000 now, and this is still a ridiculously low number. Because if you are a small provider, you end up, and it's the worldwide user count and not just the Swiss users. And I mean, I always say it's not possible to run an OTT communication service if you only have, let me say, 10,000 people, because these people, if they pay, even if they pay 5 francs or 5 euros per month, you don't make enough money to have this up and running for a long time. It's just not no viable business, and that's why this number of 10,000 is way too low, and that's something we try to change. At the moment, there is a so-called regulatory impact assessment is going on. So the companies that are involved in these things and that provide these services are being asked by a company that was mandated by the federal by the Confederation to find out where the impact really is. I mean, we have these words of Andy Yen of Proton, who went to newspapers and said, look, if we have to implement these changes, we will leave Switzerland, and they will find out how other companies see these things. Also, NIM has been sent a questionnaire, and I really wonder how the results will be. My opinion is clear. I mean, if you have lots of companies that really deal or do business in the privacy sector, if you introduce such rules, these companies will just say, look, we will have to leave the country, and this is going to be a big drawback for authorities who want to introduce these new rules.
Yes, indeed. Now, we also I shared this with the community on our forum when we were asked about this as well. Obviously, this is not, as hopefully everyone understands in the audience now, this is not even close to be a done fight at this point. But you know, if it does pass, especially in its past form, this ordinance, then you know we would also have to consider setting up shop somewhere else. So let's hope it doesn't pass. And that brings me to my next question, actually. what are the current chances, you think, if you have to pull out your crystal ball? Does this make it through in some way, shape, or form, or not likely?
It's difficult to say. I mean, the ordinance itself is not enacted by the parliament. It's enacted by the government, which is the case with ordinances. And the government usually listens to the administration, to this administration of surveillance, and they are, in my opinion, quite pro this, even the old version. So the risk that this could be enacted is there. At the same time, there was really a big fuss on in this area. You had newspaper articles, you had many companies complaining. As I said, you have politicians that filed papers in the parliament, and I think they are now aware that there is really a risk that this is going to be to fly into their faces. And what we also have to see is that we already were successful once in court by fighting such steps by the federal authorities, surveillance authorities, and they always have to face the risk that if they would enact this in the way it is planned at the moment, that we would go to court. And there will definitely be companies in Switzerland that would go to court, that would appeal against the ordinance. And there is still a good chance that this is going to be overturned by the courts.
Okay, excellent. It's a bit less hopeful. Maybe you're being diplomatic here and don't want to set high hopes. I hope actually the situation is a bit more rosy than that, and I really hope that this does not pass, because it would not be great.
Yeah.
Now, my last question for you before we jump into the community questions is a bit of a bigger picture one, because I think you also mentioned a few examples, from the United States. We also brought up chat control before. It looks like, and not to mention, other parts of the world, of course, where this technological sort of surveillance is becoming more and more institutionalized. Is that necessarily a trend that will have to happen and will have to just get worse going forward, or is it just my bubble? I'm obviously very aware of what happens in the privacy space. I care a lot about this, as you may have guessed from me working here at NYM. Is it really as bad as we think it is? And more importantly, is it like a global trend that will move forward in this direction in the future as well?
Well, it's difficult to say. I mean, we saw the discussion in the EU with mass surveillance, where we had the Supreme Court, Supreme EU Court, turn it down. So there are rules, there are very basic rules, constitutional rules on EU level, also in Switzerland and in other countries, that prevent such things from happening. At the same time, I mean, also constitution, from my perspective as a lawyer, also constitution is sort of like, it's a text. You have to interpret the text. It is sort of not hard, a hard thing to work with, but it's soft, it can be formed. So there is a risk, of course, that these things will continue. This trend will continue. At the same time, I mean, you asked me in the beginning about Switzerland being sort of a privacy heaven. I'm not sure. In the end, in our country, you have a direct democracy. We'll have to ask the people if they really want these things. And I'm not sure if you really will be successful by enacting such laws. Above all, I mean, privacy in general has become a big subject. I was recently in a bar in Zurich, and I tried to pay with my watch and the payment system that is provided by my watch provider. And the guy behind the bar, when I used this, he looked at me like that and said, "Are you not afraid of privacy issues if you do this?" And then I thought, okay, it's surprising. If the barkeeper thinks about privacy. This has arrived somewhere in the whole population. We also had votes recently on a digital ID in Switzerland, where almost half of the population tried to turn it down. Now we have it, and I'm glad we have it, because the system itself is really has been designed very thoughtfully. And it's, well, you have open source software, you have access to the whole design, everybody sees what is going on. This is very good. It's, in my opinion, it's better than the EU system. But still, there is, I mean, you have, people are starting to understand that privacy is a value on its own. And that's something that is good. And so I'm not so sure if this is really going to be a trend that cannot be stopped. But still, I mean, you have this saying of the frog that is being thrown into cold water, and then you heat up the water. People will not, or the frog will not notice until it's dead. And if you look at these things, it's a bit similar. I mean, you have surveillance, then they introduce a new step, they introduce something new, and it gets common, it gets usual. They have a new step. This is also a risk that might happen. At the same time, I mean, there are lots of people around who really object to these things. They're quite vocal on these things. And I think it will not be so easy.
I hope you're right, and I will also share, before we jump into the community questions, my heuristic, which could be wrong, but I honestly think that direct democracy could be one of the solutions to, you know, like our protections against this kind of stuff. Because when I look around and I see the questionable proposals in terms of end user privacy, that would mean mass surveillance in one way or another, I never saw a single one that had any public support, basically. So if you look at chat control, you can't show me a single like private you know, association made up of private people who would be like, yeah, I want chat control. It's always law enforcement. And, you know, if you have direct democracy and it has to go through the actual people, you know, in the form of a vote, that's, I think it's a fairly good like check and balance.
I mean, there is one problem. If you look at many of the big companies doing telecoms in Switzerland, and if you look how they react to these ideas, they just don't say anything, because I don't know where the problem is. Maybe they think that if they publicly speak out against it, they are afraid that people would say they are pro-criminals or whatever. I have no idea. I don't understand them. So it's usually, quite often you have small companies that try to stand up against such regulations. You have, of course, now we have operators of privacy centric systems like NIM, like Proton, like Threema, who really have their business depending from these decisions, and of course they will stand up against it. But the big telecoms companies, they usually stay silent, and this is something that, let me say, fills me with some concern, because it's quite often the big companies that really have influence to politics. That's a point that's difficult. I mean, Switzerland, if you look at Swiss politics, economy is quite important. So if you are a big company, if you have a big association of companies, it's quite important what they say. And if they just remain silent because they are not interested, because they say, look, if we have to do surveillance, we don't care. This is critical. And that's why it is very important to have small companies like yours, like the others I mentioned. And for instance, also like another client of mine, which I hope I can mention here, Init7, which is a telecoms provider who's really very, very strong and trying to fight these developments. We have been in court for several times to fight privacy restrictions. If you have these companies, the question is always if it's sufficient, if the small companies are standing up, or if it would be better if the bigger ones would also do something. So, I mean, if you have a provider, if you have a big provider, and if you're not happy that they just do not do anything against it, you might ask. You must send them an email. Why do you not react? I think it's a question of publicity. I mean, if these providers are in the news, and if it says, look, the big provider XYZ, they do not think about privacy. It's not important for them. I think it's a matter of reputation as well. So that could be a thing how this could gain momentum.
Yes. Or maybe the other good solution is to make the companies who are now small, standing up for these things, make them very big. And then, we basically leap.
So switch
the problem.
the provider if it doesn't support privacy.
Exactly. That's a good point. Big thanks for this illuminating chat. I learned a lot today. So thank you, Simon. Now it's time to jump into the community questions. We have quite a few. So let's get started. Rocio asks, is there a legal way for a decentralized protocol or a mixed net to comply with these laws without compromising its technical integrity? Or are we facing a de facto ban on mathematical privacy?
Well, at the moment, as I said, this law is still in the making. If it will be here, I mean, if you have a system like NIM, we have a very decentralized setup. We have operators of nodes that are somewhere scattered somewhere all over the world. For authorities, basically, they can approach you if you operate a NIM node, and they can ask you for the information. But still, I mean, first, you don't have the information, at least based on the current law. You, as I said, you only have to give to provide them with the information you have. You already have. You don't have it at the moment, so they will not be. It will not be worth anything for them contacting you. And the next point is, even if you're, if you're a small operator, a small node operator, you will probably not even get over the thresholds that the law sets for those higher or more, let me say, strict duties that I mentioned. So I think it's more like a practical thing. They don't know how to approach these people. The next question will be if NIM, as the operator of the basic infrastructure, is a telecoms operator in the sense of the law. Maybe not. The operator of a NIM node might be one, but at the same time, it's so small that it's not interesting for the authorities to get in touch with you. Furthermore, I mean, these operators are scattered all over the world, so they could also take only catch Swiss operators. So this is another, let me say, security network you have.
Exactly, the beauty of decentralization. Thank you for that answer, and thanks for the question, Rocio. Let's move on because we have quite a few questions in very short time. All right, Jeannie's asking, do you have any laws you personally would pass if you were the ruler of EU policy?
Well, I would pass an article in the basic EU agreement or the EU contract that prohibits chat control. It's probably not something that's going to happen.
Yes, I actually considered. Sorry, go ahead.
But it's also, I mean, this chat control discussion. We had a decision of the Supreme EU courts that said that mass surveillance, data retention for I don't know, 6 months, 12 months, whatever, that this is illegal. If you look at chat control, I mean, this even goes further. So I would expect that such a thing would also be cancelled again by the Supreme Courts. So I'm not so sure if this will even come if the Parliament wants it, because you still have the separation of powers, and this works quite well also in the EU.
Fun fact, just a quick note, I thought about starting an EU citizens initiative for this exact purpose, that, we sign this, that we never ever want chat control, and however many times it comes back, we always just want to say no. But then it got dropped again, so I didn't do it, but I will if it comes up again. So maybe you and I can join forces when that happens. Thank you for that answer, and thanks for the question, Jenny. Next one is from Papu. If I understand correctly, you don't collect logs. I think this is for us. Answer is very short. We don't. And we also ask our operators not to collect logs, right? There are some technological guarantees that logs cannot be collected, and then there's also some legal requirements for operators to never ever log any of their users. So there are two fronts where you're safe when you're using the NIM network. Thank you for the question. Next one is also from Papu. What happens to NIM, Proton, and other privacy companies when this passes? I think we already kind of discussed this. Maybe like a quick, short answer. Simon, what happens?
Well, I see some companies who announce that they will leave Switzerland.
Yeah. So basically, that's your answer. Hopefully it doesn't pass.
Yeah.
Fingers crossed. Next one is from Mr. Zero Day. Thank you for the question. If that were to happen, wouldn't users be able to do anything? Would we just have to accept it or use apps outside of the law?
I mean, the question is, what would you want to do? I mean, you have, if the big operators, they will probably have to follow the law. If they cannot leave Switzerland, if they would leave Switzerland, there might be a way to catch them, to still catch them. I mean, if you have rules applying for app stores, for instance, that they are only allowed to have apps that comply with the law. I don't know how they would want to make it, would want to implement it. There is a certain risk. Of course, I mean, if you look at systems like the iPhone, that is quite closed. Okay, you in the meantime you have different app stores, but it's not very common to use them. If you have systems like Android, you might have more freedom, but still it's difficult. I mean, one point with these systems is that you have network effects. So if you're the only one who's using this application, this messenger, it will not be of any use for you. And that's, for instance, for me. I mean, I have some contacts I can only reach via WhatsApp. So what do I want to do? I have to use WhatsApp, and that's exactly one problem we have. You cannot do big players, and that's actually the reason why I'm convinced that we need strong privacy laws that also apply to these big players, because it's not just the market. Because the led to a situation where you have big players that do not really care about privacy. I mean, you have end-to-end encryption with WhatsApp, but you do not have the information who was in touch with whom, who knows whom. They know this information. They will also give it to the police. And yeah. So you have to use these systems. And one very important point is that you need laws that protect us as citizens from companies that go too far privacy-wise. Still, I mean, you have options. You can switch if you have a specific circle of people who really are interested in discussing internally with high privacy. You can use these systems, and of course, I mean, if you look at systems like Threema, if you look at systems like Signal, they are very good in privacy, and they have their user base, and it works. So. You can also try to convince your colleagues to use the other stuff. As I said, privacy has become a bigger topic in the last years, also for average people, so it might be possible to convince them.
Yes, amen to all of that. And I do definitely see in the privacy first communities that I'm aware of, and also they just reported themselves as well, that there's massive growth these days. The world is entering some turbulent times, and people, and also we see some pretty worrying developments in some ways, both in the like a corporate and government fronts when it comes to privacy, and people are becoming more aware. So definitely, it is a growing concern for everybody. I think that brings us to the end of this conversation. And before we wrap up, let me make just one announcement that is unrelated to this conversation, but I wanted to share it with the community because I have to share alpha whenever it's available. So just bear with me, Simon, for 1 second. Dear NIM community, there is something that we promised for a long time that is finally getting revealed or launched very soon, which is the NymVPN referral program. Now, there is the boring part, which most VPNs have, which is, you get an extra month if you refer people, and they also get an extra month for being referred by you. But the reason why I'm bringing this to the community call is because for NIMS Quad League participants, so our closest core community, there is going to be some extra special stuff that we develop for you, which definitely does not belong to that boring category that I mentioned earlier. So actually, this will be a big upset to the reward structure of the NIMS Quad League. So the prize pool for NIMsters will go up by 10x from 50,000 NIM to 500,000 NIM if you play your cards right. And the reason why I'm sharing this with you is because the system launches with the next season, which is as of April. But you can already, like, your referrals that you do until then will already count against your score for the next season. That's all I'm gonna say. That's all I'm going to say for now. There are also going to be some funky in real life or like physical prizes, I should say. So make sure to stay tuned for that. And once the referral program launches, start using it because it could benefit you greatly. All right, that's out of the way now, Simon. So from this other Simon, I want to once again thank you for joining us today. This was really illuminating. It was lovely to learn about this topic more in depth. I definitely learned a lot. Do you have any closing remarks before we wrap up?
Well, privacy is important. Think about it. Try to keep your stuff private. That's important. And yeah, thank you very much for having me here. It was a pleasure.
Thanks for joining. Stick around for just another minute because we have a little tradition here. With the NIM community, which is that we give our participants a little NFT to commemorate us hanging out together. So we are going to do that. And the secret phrase, which unlocks, wait, where is it? It's here. Yes. So the secret phrase is something that I left for you specifically, and I want you to say a few words about it. So you need to do the same, my dear community. You need to go to nym.com/go/POAP. And the secret phrase today is net neutrality, capital N, capital N. I actually initially had a few questions planned about this to the main part of the conversation as well, but I saw that you wrote actually a book about net neutrality. This is a bit outside of NIM, so I didn't end up putting it in the questions. But this is a cause that's very close to my heart personally, and also it's something that I feel like has been forgotten over the past few years. There was a lot of discussion around net neutrality, but not so much these days. So I wanted to pick your brain just in 1 or 2 minutes. What is net neutrality and why should people care?
Well, I wouldn't say it has been forgotten. It's been implemented in the law. There's a Swiss law that protects net neutrality, and it's been enacted and it's been enforced, so it works. That's a good thing to say. Net neutrality means that, well, in simple terms, an access provider is not allowed to differentiate between different providers, between different data streams, etc. So, for instance, if you are a customer of let me say, Swisscom or whatever, Swisscom would not be allowed to let me say, block NIM for you and only allow you to use other VPN providers, for instance. So they have to pass through everything. They are not allowed to intervene with data streams that are passing, except for cases where you have, let me say, criminal stuff, etc., where you have the government that tries to stop you there. We currently have a big case running in Switzerland in that area. But net neutrality basically says that internet access providers have to be neutral towards towards the services and the apps, etc., that are available on the internet. And that's quite important because there were times when access providers started thinking about making, let me say, specific deals with such providers. So, for instance, you would have only been able to use WhatsApp if you're a Swisscom customer and not Threema. For instance, these things have been around, and this has been stopped.
Okay, so then I learned yet another thing. How net neutrality mostly entered my perception was through like an American lens. Most of the content creators about tech are Americans, and they spoke, I think about 8 years ago or something. There was a lot of talk about it. It never actually happened in the States. So I think our American viewers are very jealous right now, based on what you just said, right? So in America, there's no net neutrality still.
Actually, there was a law. There was a federal law on net neutrality, as far as I understand, but the Trump government has killed it.
Oh yeah. Well, so yeah, that's one more reason to be jealous of Switzerland. Simon, I won't take up much more of your time. Thanks again for joining us. This is very illuminating, and also big thanks to our community for listening. And hopefully, maybe I can have you back to celebrate the law not the ordinance not passing. Let's hope we can do that in the near future. Big thanks for joining us today. Big thanks for listening in, my dear community, and see you next week on Thursday. This time for real. It's going to be on Thursday again for another one of these calls. Bye, everyone. Have a great day.